Let's look at business English vocabulary for contracts. Contracts are the backbone of business transactions, serving as legally binding agreements between parties. So whether you're negotiating a partnership, securing a deal, or outlining the terms of service, understanding contract vocabulary is crucial for effective communication and negotiation. So let's dive in. First, what is a contract? I think it's really important we start from here so that you know what it is and so that the whole of the lesson will make sense to you. A contract is a legally enforceable agreement between two or more parties that creates obligations and rights. It outlines the terms and conditions to which the parties have agreed and provides a framework for their interaction. Now, there are various types of contracts in the business world, such as sales contracts, employment contracts, partnership agreements. Now, sales contracts refer to agreements outlining the terms of sales of goods and services, while employment contracts, they are contracts between employers and employees specifying terms of employment. Then moving over to partnership agreements, these refer to contracts establishing the terms of partnership between two or more parties. So now that you understand the basic definition of what a contract is, let's explore some key contract vocabulary. Let's start with agreement. An agreement is a mutual understanding or arrangement reached between two or more parties. In the context of contracts, it typically refers to a legally binding agreement between parties. Moving on to offer. An offer is a proposal made by one party to another party, indicating a willingness to enter into a contract on specified terms. The offer may be rejected, accepted, or negotiated, which can lead to the formation of a contract. The next is acceptance. Acceptance occurs when the parties agree to the terms of the offer, creating a binding contract between them. Acceptance can be expressed verbally or in writing, or implied through conduct, depending on the circumstances. Now, let's discuss consideration. Consideration is something of value exchanged between parties to a contract. It can take the form of money, goods, services, promises, or forbearance. Consideration is essential for a contract to be valid and distinguishes it from a gift or a gratuitous promise. Moving on to the next, we have terms. The terms of a contract refer to the specific provisions, conditions, and obligations agreed upon by the parties. These may include payment terms, delivery schedules, warranties, dispute resolution mechanisms, or indemnities. Here, indemnities refer to provisions made in contracts where one party agrees to compensate or protect the other party against losses, damages, liabilities, or expenses that may arise from specific events or circumstances. Let's talk about performance. Performance refers to the fulfillment of one's obligation under a contract. It involves carrying out the duties and responsibilities specified in a contract in accordance with agreed upon terms and conditions. Moving along, we have breach. A breach occurs when one party fails to fulfill its obligation under a contract without a lawful excuse. It can involve non-performance, delayed performance, defective performance, or repudiation of a contract altogether. A breach may entitle the non-breaching party to remedies such as damages or specified performance. Next, termination. Termination is the act of ending or cancelling a contract before its full performance. Termination can occur by mutual agreements of the parties, expiration of the contract terms, or as a result of a breach or other contractual provisions allowing for termination. Did I say contamination? Oh my God. Allowing for termination. The next essential term is damages. Damages are monetary compensations awarded to a party for loss or injury resulting from a breach of contract by the other party. There are various types of damages, including compensatory, consequential, punitive, and liquidated damages. These aim to compensate the injured party for the losses and restore them to the position that they would have been in had the contract been properly performed. Next, we have indemnification. Indemnification is a contractual obligation where one party agrees to compensate the other party for certain losses, damages, or liabilities arising from specified events or circumstances. It is often included as a provision in contracts to allocate risk between the parties and protect against potential financial harm. Moving on to force majeure. This is definitely a Latin word, and I hope I'm not murdering the word. So, force majeure is a contractual clause that excuses performance in the event of unforeseen circumstances beyond the control of the parties, such as natural disasters, war, strikes, or government actions. It relieves the parties from the obligations under the contract events during the occurrences of such events, which are typically considered force majeure events. Let's discuss confidentiality. Let's discuss confidentiality. Confidentiality is the obligation to keep certain information shared during the contract period confidential and not disclose it to unauthorized parties. Next, we have arbitration. Arbitration is a method of dispute resolution where parties submit their dispute to a neutral third party, which is known as the arbitrator, for a binding decision. It is an alternative to litigation or going to the court or, having a lawsuit, and it offers a faster and less formal and often more cost-effective means of resolving conflicts arising from contractual disputes. Next, let's touch on jurisdiction. Jurisdiction refers to the authority of a court or legal system to hear and decide a case. It determines which court has the power to adjudicate disputes arising from a contract and applies the relevant laws and procedures governing the resolution of these disputes. Moving forward, we have representations and warranties. These are statements made by one party to another regarding facts or conditions that are material to the contract. Representations are statements of past or existing facts, while warranties are promises or assurances about future performances or conditions. They serve to provide assurance, induce reliance, and allocate risk between parties. Next, we have governing law. Governing law is a specified law in the contract that will govern its interpretation and enforcement. It determines the legal framework within which the contract will be construed, including the rights and obligations of the parties, the validity of the contract, and the available remedies for breach. Remember, we talked about breach, so you know what a breach is. I think you do. And finally, severability. This word's really hard for me. Severability. Now, this provision allows the remaining terms and conditions of a contract to remain valid and enforceable, even if some parts are deemed unenforceable or invalid. And so, we've looked at vocabulary for contracts, and we looked at agreements, mutual understanding between parties. So let's say like Chidi and Dimma, they reached an agreement with the House of Chito that was mutual understanding. So they gave them a proposal. So we're going to put your clothing line on high-end stores, and then we're going to give you so and so percentage for your loyalties, or we're going to pay you so and so. The acceptance was what? Was when Dima and Chidi accepted the contract or the terms of the contract. And then there was now this is really tricky, because for Dima and Chidi, they did not fully understand the contracts or the terms of the contract that they were going into, and that is really a bad thing. So next time you have a contract, please ensure you go through every one page of the huge document that I presented to you, because buried deep within those documents, you may find terms that are not really favorable to you. Then you can renegotiate and ensure that you don't go under by the time the contract is fully executed. And then we have termination. For Dima and Chidi's contract with the House of Cheeto, it was terminated before its full performance because Dima and Chidi were the ones suffering. It's really unfortunate though. It's really unfortunate that they did not they did not really go through the document or the contract document to understand. And so it had to be terminated, and they were not compensated. There were no damages that were paid. This case, let's say the case goes to court, or a court with the jurisdiction to handle such a case of Dima and Chidi versus House of Cheeto, right? They most likely will not have a case. They might have a case, they might not have a case. So I want you to leave me a comment, a voice note, wherever you find my podcast, from the story you're listening to. Do you think that Dima and Chidi have a case in the court of law? Let's say they go to court. What defenses do you think they'll be able to come up with? Because this is a really tricky one. House of Cheeto would say that they gave them a contract. They would produce a document, and so Dima and Chidi would have to come up with other defenses. Maybe, let me think. Let me try to think. Let me try to think. Can they come up with mental stress or ignorance? Is definitely not a defense in the court of law. I didn't know it was there in the document. It makes you sound like a fool. What defense can it come up with? So leave me a comment and let me know. Yes, let me know. And then definitely I think they can have an arbitration, or have an arbitrator who would try to mitigate between the two parties. I don't know how well that would go, really. But then it's very, very tricky. It's a very, very sour tale, because they just did stuff out of ignorance, out of excitement. That's why it's always not good to act out in a hurry. Okay, so this wraps up our episode 15 of Business English on essential contract vocabulary. So make sure you listen to the story part if you've not listened to it. It's really interesting, and it's really a cautionary tale. Don't forget, to follow my podcast on Apple Podcasts, on Google Podcasts, on Spotify, and I will see you in episode 16. Till then, keep speaking and keep growing.